We'll turn back now to Vermont, where a sentencing hearing is underway for Joseph Ferlazzo.
He confessed to killing his wife, Emily, when he took the stand, but he said he shot her in self-defense. Obviously, that jury did not believe him. They did find him guilty of first-degree murder. Ferlazzo is now facing up to life in prison.
However, before we do go back to court, let's bring in our guest for this hour. Joining us, criminal defense attorney Jeffrey Wolf. Jeffrey, great to see you. Thank you so much, as always, for joining us here on the program. And I want to get your thoughts on what's happening here. I mean, the state is laying out, there's so much to work with here in terms of aggravating factors. And the aggravating factor is particularly important here because that 35 minimum in this case per statute can either rise and fall based on whether the aggravating factors outweigh the mitigating factors.
Yeah, absolutely. That's the way a sentencing hearing is always going to work, right? You're going to have the judge considering aggravating and mitigating factors. And the way I always explain it to clients is aggravating things make it worse, mitigating makes it better. So anytime that you have something that you can bring up to the judge that makes you look better, you're mitigating the circumstance. Anytime the prosecution has something that aggravates it, it makes it worse. So what the prosecution is doing, and what they're doing rather astutely, is taking what the defense has done to try and mitigate things and using them to aggravate it even further. So these character letters that have come in of these women who have said, we met him, he's a good guy, he was so kind to us, they're saying basically he was grooming these women for further relationships. And that is dark, okay? Taking the character letters of the defense and using them against him is extremely dark. That is, if those letters were not vetted well by the defense team, that was a huge mistake.
Well, you know what's interesting is the code specifically states that the state has the burden beyond a reasonable doubt, not only to show the aggravating factors, but to also prove the absence of mitigating factors. And I feel like that's what they've leaned into, Jeffrey, by kind of twisting what the defense has used to say, no, and now saying the only mitigating factor he has is no criminal history. Do you think a court might agree with that argument, that that's it? That's the only thing he has as a mitigation, is he does not have a criminal history?
Well, I think that is the only one that they can't refute, right? Because a lack of criminal history is just a fact. When you haven't been arrested before and there's nothing to point to saying you have a criminal history, that is one that they can't get around. So now what they have to do is attack everything else. And because of that, they have to confess that one, and then they can attack everything else. And so when you can't get around it, you say it's the only one that exists.
That's fair.
Jeffrey, I wanted to ask you, because oftentimes you have the same mind as far as this goes. Do you think the prosecution might be going too far in terms of, like you mentioned, using the letters that were brought in to support him to suggest, with, I'm going to say, not a whole lot of evidence that he was actually trying to groom them, that this was a possibility, things along that nature? You think they're going too far?
Well, I often think that with a jury, okay? And so I think that if they were doing that in front of a jury, I think they may run into that. But when you're doing it with a judge who has just sat there and listened to the trial and seen somebody get convicted, oftentimes judges are former prosecutors, and you find yourself as the defense sitting there and dealing with two prosecutors during a trial and certainly during a sentencing. And so what they're doing is they're throwing red meat at a thirsty dog with this judge. And so they're probably not going too far with the judge. The judge is probably licking their chops at this, quite frankly.
So it sounds like yes, but not with this particular judge, because he's a former prosecutor. Right? I got you. All right, stand by, Jeffrey. We're going to get back into court now for more of the state's oral argument ahead of the judge's sentencing.
After the murder, noted that he was not abusing marijuana. He was using it, but not abusing it, and that he wasn't drinking at all. His sister didn't know any drug or alcohol use of concern. He had one mimosa at breakfast. When speaking with police, he didn't indicate any extreme drug or alcohol use and had a very clear memory of what occurred. This new claim of drugs and alcohol being to blame is just another way for Mr. Ferlazzo to deflect blame from himself. If he were in the throes of alcoholism or drug abuse, all of the people that interacted with him that weekend, and it was many, would have noted some level of problem. And there's no evidence of this. This is not a case about alcohol use or drug use. It is a case about rage, violence, control, abuse, and lies. There is zero evidence to support that drugs or alcohol played any role in what Mr. Ferlazzo did to Emily. As to any noncompliance with court orders or failures to appear, of course, Mr. Ferlazzo has been incarcerated since this incident, but the state would note that the evidence is clear that he did repeatedly lie to try to get out of this case while making plans to hide Emily's body. The risk to self, other, and community at large presented by the defendant, Judge, the state would submit that there is no greater risk to the public, specifically the women in our community, than a man who is unfaithful to his 22-year-old wife, blames her for not allowing him to be unfaithful, scares her, intimidates her, and then murders her when she tells him she doesn't want to be with him anymore, stabs her body 18 times, including through her heart, goes about his weekend with friends and family as if he's completely unfazed, dismembers her body, puts her in trash bags, and then blames her for the entire thing. There is no greater risk than a man who refuses to accept responsibility and thinking that believing because he admitted to killing her is the same thing as taking responsibility. This is not an acceptance of responsibility, and simply saying that he did it is not the same thing. The state would remind the court that days after murdering Emily, knowing full well where she is, he sent her a text message stating, Mr. Ferlazzo appears to believe that every woman that he engages with owes him everything, including their life, and is owed nothing in return. This type of ego and the risk it poses to his next potential partner cannot be overstated. When thinking about comparable cases, Judge, in Vermont, I struggled to find a case that adequately compares to this one. The premeditation, calculation, post-mortem dismemberment, post-mortem behavior, lying at trial, continuing to lie for the PSI, tearing apart the victim impact statement in a sentencing memorandum, all feels incomparable. Again, had Mr. Ferlazzo simply made the state prove their case, the state would likely be asking for somewhere in the range of the mandatory minimum, or something close to that. But that is not what he did. He got on the stand and made the very deliberate and unnecessary choice to lie and blame Emily for her own murder. To testify that she was assaultive, not just towards him, but her beloved dog. The court saw how Emily interacted with Callie, Remington, now Callie, and the kittens, to think or to put forth that she might harm them from the state's perspective is an aggravating factor. He then doubled down on that statement again when he tore apart every sentence that Emily's family stated in their victim impact statement. He's gone to extreme lengths to discredit her, to blame her, to insult her memory, and to insult her family and friends. The complete detachment from any sense of self-recognition and accountability in the state's opinion should be met by this court with a greater punishment than the mandatory minimum. The closest comparator in recent history the state could think of is a Tukarang, in which court is well aware of the extreme circumstances in that case. And even in that case, after trial, in which Mr. Grung did not testify, the court sentenced him to the mandatory minimum of 35 years.
I did not. No, it was a split to serve
27.
a lower amount.
The state believes the case is significantly more aggravating and deserves a significantly higher sentence. And the state's only briefly, Judge, going to address Mr. Ferlazzo's request for a sentence to say that the state understands the position the defense needs to take, but this request of 15 years is an insult to Emily. It's an insult to her family and her friends, the Vermont State Police, the people of our community and state. 15 years, followed by probation for the premeditated murder of his wife, for jumping on top of her, pinning her down, putting a pillow over her face and shooting her twice, by stabbing her body after dismembering her, cutting her into pieces, putting her in garbage bags, and then going about his weekend, and then consistently lying about what happened at trial and since. Had Mr. Ferlazzo been found guilty of voluntary manslaughter, 15 years would be appropriate, but he was not, and so it is not, and the state believes that Mr. Ferlazzo should get 15 years on top of the mandatory minimum. because of his behavior at the time and since. Finally, Judge, you heard from Emily's parents, David and Adrian, her brothers, her best friend Lauren. You haven't heard from countless others in the courtroom and the community who knew and loved Emily. Every single person that knew her, or even some that didn't, feel her loss deeply and immensely. Her smile as the court saw, her incredible voice, her kindness, her love, and her contagious laugh. If they were all allowed to speak, they would. Her aunt and cousins wanted you to know that she is spunky, she was full of life, bright, driven, talented, dedicated, compassionate, and full of laughter. They want to know, the court to know that they are here for her and that they feel her loss every day. The state, Your Honor, is seeking a sentence of 50 years to life to account for Mr. Ferlazzo's actions at the time and since, and the risk he poses upon release. With good time, the state expects he would be eligible, he could be eligible after 40 years. Mr. Ferlazzo was nearly 42 at the time. Emily was 22. He had twice the number of years on this earth than she did when he killed her, and it seems reasonable he should spend the same number of years inside a jail that he had the opportunity to spend outside of it. Thank you.
Thank you. Thank you.
All right, Judge State putting the hammer down, asking for 50 to life. He'll have to serve minimum 40 under the rules there. What do you make?
I think that I'm not surprised the state's asking for that. We haven't heard from the defense yet, but I think that this judge, it's going to be a heavy-handed sentence, I think, based on the facts.
Yeah, no question about it. All right, we're going to take a break here, folks, and coming up, the defense gives their oral argument in favor of convicted murderer Joseph Ferlazzo, trying to get the least time possible. Keep it here on your front row seat for justice.
You got us banned from being room parents? I have never been more in love with you.
Who wants to go nuts for donuts?
Show him your folding trick.
I'm not in the mood for your sheet right now.
That's gotta hurt, huh? You keep me coming back for more.
Bounce elevates and celebrates the achievements of HBCUs all year long.
From the classroom to the field, we are making history.
Bounce HBCU Yearbook.
Ion is on with 3 networks to enjoy.
Yeah, it's on.
Yes, showtime.
You're gonna want to see this.
It's on.
Ion, Ion Plus, and Ion Mystery. It's on. Coming soon to Court TV.
It's the biggest story that we're covering.
He is the boogeyman.
Lori Daybell.
She said, I will have you destroyed.
She's got another murder trial coming up.
A social media sensation, now a suspected killer.
We will not stop fighting. We have no quit.
Sean Diddy Combs arrested on a federal indictment.
The high-stakes trials you don't want to miss. Coming soon, only on Court TV.
You go get him, Tiger.
Oh, yeah.
I didn't hear anybody knock. Shall we proceed?
My paw is the best shot in the whole world. Isn't it exciting?
They call you the rifleman. Just make it good.
I wanted to be a reporter since I was 4 years old. I always knew that I wanted to tell stories. I feel really proud that I work at Scripps News. Our reporters get to delve into the topics that we care about and that we want to dig deeper into. There's a real investment in going where the stories are, giving people the full picture, reporting what is happening firsthand. Alex Miller, Scripps News, New York.
For live reports, breaking news, and headlines from across the country, stream Scripps News.
Start watching TV for free with Tablo.
Switching to Tablo has really been a money saver.
With Tablo, I can record something on my phone, I can pause it, I can go get a drink, I can come back, I can continue in the family room.
Order today at TabloTV.com.
How prepared is your family if disaster shows up at your doorstep? You can't just turn away a natural disaster. That's why it's important to go to ready.gov/plan before they show up. It has the tools and tips you need to make an emergency plan with your family. So if disaster comes knocking,
let's go.
You'll be ready to help keep your family safe.
It's just a pizza.
Yes!
Make a plan today.
Join the case that puts you in the middle of the mystery.
The answer's in front of us.
And keeps you guessing till the very end.
It's anyone's guess who's next.
Every twist, every turn.
Everything we need to find this guy is right here.
Eye on Mystery. Join the investigation.
Back to Vermont, where a man convicted of killing and dismembering his wife will learn his sentence today.
Joseph Ferlazzo shot and killed his wife, Emily, while on an anniversary trip in Vermont. But he says he shot her in self-defense.
Ferlazzo's sentencing is underway. We want to get back into the courtroom now for the defense team's oral argument.
Just have a few brief comments in response to the state's argument. And the first is to remind the court, which I'm sure the court is well aware of, that this is argument, not evidence. The state has made interpretations and made allegations and about Mr. Ferlazzo.
I will say this: I am only going to consider evidence that was introduced in this case, and not things that may very well be true, but are not part of the record.
That was my,
and
that's where I was going.
I'll further say that decisions counsel make to litigate certain issues pre-trial, I'm not going to consider that as a aggravating event either. There is a lot which the state has said that I am going to consider and have been considering, but
Thank you, Judge.
Those things I will not.
Thank you. Those were some of the things I was going to raise in response to the state's argument. The state, one thing that I would like to raise, though, is the state has repeatedly referred to his testimony at trial as lying and has endorsed the perjury allegation. He has not been charged with perjury. This court, I'm asking to not consider perjury as...
So how would you have the court consider it if the court finds it entirely incredible, and I don't want to mince words, I do. How would you have the court interpret it?
So over the lunch break, I looked up 13 VSA 2901A, perjury by inconsistent statements. It has 3 prongs. That the person knowingly makes 2 or more statements under oath or affirmation which are material. That's the statement to the police and the statement at trial. And the statements were made within the period of statute of limitations. The one that I don't think there's evidence before the court is that the statements are inconsistent to the degree that the person necessarily believed one of them to be false. And I don't think there's evidence before the court that Mr. Ferlazzo...
So how do you interpret how he could... I'm fascinated in this question. I wish Dr. Powell would have discussed it. I asked him just a few questions. He didn't think much of the amnesia post-clarity. But how do you interpret that he has a detailed memory of something vastly different, which is much more consistent with all of the evidence, and then over the course of a few years has amnesia for almost every event, except a different version now for what occurred?
So I certainly am not a psychologist. I'm just a lawyer. Neither is the state. And to ascribe his motives in the inconsistent statements to deliberate deception. I don't think anyone in this courtroom can do. He testified that he had been drinking constantly. He testified to that on the stand. And for a chronic alcoholic, my layperson's understanding is that they can be functional if they are, if I may, chronic alcoholics. So the fact that no one else may have noticed that he was constantly, continuously intoxicated over the course of the weekend is not surprising from a layperson's experience having been doing this job. His testimony was a few weeks after the event, he began having dreams about what happened and remembered more clearly than what he said to the police. Now, we have all seen the video, and he appears to be quite rational in the video. That's my explanation, because it's all that's what Mr. Ferlazzo testified to. He began to remember after the fact, after he talked to the police.
So would you agree with the court statement that either he's intentionally lying or he has done whatever he needs to do to psychologically be able to live with himself and has essentially reinvented a story?
So I can't agree with either of those, Judge, because his testimony was not to that effect.
Okay.
I'm not a psychologist.
Right. Good enough.
All I know is what he testified to. He remembered it. Whether that is a function of his having to live with his own actions, I'm not qualified to say. Okay. And I don't think the court is either.
Okay.
His testimony is what it is. But to ascribe it to being a deliberate lie, I don't think there's sufficient evidence before this court, which there has to be a preponderance of evidence in sentencing, and the burden is not on him about any facts that are alleged for the court to take them into consideration for sentencing.
Okay.
And I don't.
Still with us, criminal defense attorney Jeffrey Wolf. All right, Jeffrey, if you're that defense attorney, how do you feel when the judge is weighing in and starts peppering you with questions, including that, well, was he intentionally lying or telling himself what he needs to tell himself to get through it? Do you agree with me, counsel? That's one of, that's the case. And I don't know, I'm a little surprised the judge is doing this. Your thoughts?
I'm not surprised because it happens all the time and I'm routinely infuriated by it. Thanks for asking, Ashley.
I don't know what you're saying about judges there, but okay.
I'm routinely infuriated. She's doing a great job of keeping it in, and she is being professional. That's what you got to be. She is refusing to back down, which is what you got to do. And she is making a good record, citing case law, telling the judge what the statute says and why she is right and why he is wrong, and he's going to make the decision he's going to make, and she's going to have the appellate record for her client. And that's what you got to do, because judges do it routinely. They have their mind made up. They think they're right. They interrupt you. They interrupt your argument in a way they don't do to the prosecution. As defense attorneys, we're used to it. We get the slings and we get the arrows. We go home. We complain about it to our spouses or our partners, and that's what happens.
Jeffrey,
Michael, I don't know what he's talking about. Do you, a judge, interrupting? Oh, I'm sorry. Did I interrupt you? Okay, go ahead.
Yes, Judge Ashley. This whole thing with the perjury. Again, we're sort of the same mind. These things kind of infuriate me as well. But I want you to give us sort of a sense of the thought behind this type of thing, where a judge is allowed to consider the fact, and again, this can have a chilling effect on someone taking the stand. They have a right to get up there and tell the story as they believe it to be. Now they have to make a determination if they consider it was deliberately lying or whatever the way you want to frame the argument. But at the end of the day, then ultimately that being used against him, not only in the guilt phase, but in the penalty phase as well, Jeff.
Yeah, absolutely. Basically what they're doing is they're saying he was found guilty, so the fact that he got on the stand and said he didn't do it, he was lying. And the defense attorney is calling their bluff, and they're saying, okay, you're saying he's lying, charge him with perjury. You're not doing it because you can't prove it. You can't prove that he was lying beyond a reasonable doubt. You convinced a jury that he killed this woman, but you can't prove he was lying. You can't prove that he knew what happened and that he wasn't just intoxicated or under the influence and thought that this isn't what occurred, and that's why he was saying what he was saying on the stand. And so to get up there and say that he took the stand and willingly lied to the jury, and to say it with a straight face to the judge over and over again as an aggravator, okay, put your money where your mouth is. Let's have a perjury trial in 6 months. Let's go. They're not going to do it.
Yeah, and you know, it shocks the conscience as far as I'm concerned, because again, it was even mentioned, people do all kinds of things to accept something they might have done. So he may have, in his own mind, created a whole new reality.
Yes.
You know, there's just so many answers to the question.
And I think that's what the judge was saying. Hey, that's a possibility defense. And they said, you know, we can't agree with that. But I think the judge gets it.
Yeah, no doubt. All right, I want to mention this. Jeffrey, stand by. If you'll notice, again, our verdict clock is up. The jury has been deliberating in the rock-throwing murder trial now for 3 hours and 11 minutes or so. I didn't even think it would take that long. But anyway, that's going on in Colorado. We'll take you inside that courtroom, of course, once the jury reaches a verdict or if they have a question.
And coming up, we'll have more of the sentencing hearing for Joseph Ferlazzo in Vermont, and we'll hear from that judge. Stay with us.